Did you know that if you tell a little white lie in the course of your lawsuit in New York, the judge will tell the jury at the very end of the case that they can disregard some or all of your testimony? You want to learn what this is about? Come join me as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. You might think, what's the big deal? It's a tiny little white lie. No one's ever going to find out. No one's ever going to know. Well, I'm going to tell you right now with almost absolute certainty, not a guarantee, but almost absolute certainty, that if you choose to lie or exaggerate, the defense is going to learn about it. If you lie about something insignificant having nothing whatsoever to do with the facts of your case, the defense will find out about it. So, for example, if the defense says, hey, Mr. Jones, have you ever been convicted of a crime? And you're saying, what does that have to do with the claims of medical malpractice that I'm making against this careless doctor? The answer is, it has nothing whatsoever to do with it. However, if you have been convicted of a crime, whether it's a felony or some other type of crime, and now you turn around and say, you know what? I haven't. And now it turns out that you have. What have you done? What you've done is create a huge credibility problem for you and your case. And you might be thinking, I don't understand. If it has nothing whatsoever to do with the details and the facts of your case, why does it matter? I'll tell you why it matters. Because in these civil lawsuits involving accidents and medical malpractice and wrongful death, your credibility is everything. And the argument the defense attorney will raise is, listen, if he now tells you a lie about something so insignificant that has nothing whatsoever to do with the facts of his case, how can you believe anything this guy has to say? How can you believe any of the details of what he's claiming in this case? If now we clearly identify and know that he's told you a lie, that he has told you a mistruth, an untruth about something so insignificant that has nothing to do with the details and the claims being made in this case. At the end of your case, before the jury goes to deliberate, the judge will instruct the jury and give them a specific legal instruction. And in New York, it's called falsus in uno. And that's a fancy Latin phrase that basically tells the jury, listen, if you find that this plaintiff, that this witness has said something falsely, now you have the opportunity to go ahead and disregard some of their testimony or all of their testimony. And now the jury can go ahead and do whatever they wish with your testimony. And if now they don't believe something that you have told them, guess what? They have the ability to throw out all of your testimony and disregard it. And now that's going to be a huge challenge for you in establishing that you are entitled to a verdict in your favor. Want more information about how these cases work? Follow me. Have questions about your matter that happened in New York? Well, if you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.